Welcome to Dad Talk Today. My name is Eric Carroll, and we have an amazing show lined up for you. We are fighting for fathers all across the United States and all across the world where you can be glad to be dad. Stick around, guys. Dad Talk Today is about to begin. Hey, everybody. Welcome to Dad Talk Today. It's a Monday night. Seems like it's been so long since we've done this. Kevin, how you doing?
Good. I just now looking over my shoulder, I guess on this side, it looks like I've got a little spaceship landing there coming in. No, I've been good. Yeah, it seems like it's been a while.
So I don't know if it was a spaceship or what, but guys, last time we were supposed to do the show is when we experienced the great Facebook, Instagram blackout of the century.
That's right.
Yeah.
Right.
Nobody knew we was going to be doing it. By the time it got back up, we was just like, hey, we'll put it off. So we're getting back on track tonight. And every 2 weeks, guys, come in here. We'll be taking your questions about family law. If you got a question, put it to Kevin down in the comments. Nothing about this creates a client-attorney relationship. Don't use it in court. You're just getting his opinion. So with that said, what's something we already got a few questions coming in, but before we get to it, guys, I promise I'll get to it. Let's talk about a little something, Kevin. What's been going on in your neck of the woods? You was telling me about a case that went down, I think, over the weekend that was just horrendous.
Well, we talk about alienation a lot, Eric, and I think sometimes people get to feel like that's all we talk about. It's all 100% dads, and that we support dads no matter what actions they take or what they do. And you and I have had a lot of conversations that's just not true. And
no,
domestic violence, domestic abuse is a very serious thing. It is a very real thing. And, we had a terrible situation this past weekend. A father that allegedly was a longtime abuser of, and I don't know if they were still married or divorced, but apparently had abused the mom some, and they have a 15-year-old son that would step in and try to protect her at times. And 6 o'clock yesterday morning, I don't know what happened, but the son and the dad ended up out in the front yard. I don't think dad was living there, but anyway, got him down and beat him up and beat the son until he died, and then went in the house and killed the mom. And then the police arrived and they shot and killed the dad. And this is all public record and actually made some of the national news. And, it just highlights something that, Eric, it seems like every time we get ready to start one of these shows, or anytime you and I are together, we wonder when it's going to end. All this violence at custody exchanges, domestic violence. It just seems as bad or worse than it's ever been. And I just wish we could see a light at the end of the tunnel.
I agree. At what point do we say, guys, something is wrong with the system? We're starting to see more custody exchanges and the shootings, the violence. It's just completely out of control. I mean, we're sitting there, not 6-7 months since John was killed at a custody exchange. This is a very serious business, guys. And I'm really down on it. I know there is a case going on in the community right now that people are wanting us to speak about. I'm waiting for more information. We got to walk that one a little bit carefully, but that goes into what we're talking about here, the reaction that people are taking from this. When you take away somebody's kids, you take away their money. I mean, look at John. John was a very level-headed guy, and he kept it together. Many people might not be equipped to do that. Right. That took a big man for him to take that as long as he did. And just knowing his ending, guys, if you haven't seen I Stand With John, it's doing good. I was showing Kevin, we're right at 750,000 views on that in just 2 weeks' time. That story has really impacted a lot of people, and we're going to keep getting out there and pushing it. But I'm going to get to their questions. The questions are starting to line up here, and I guess this would be a good one for you to start out with, Kevin. Let me look. Comes from Julio Rodriguez. He said, explain family law.
Oh, boy. Julio, there's a lot to that. And I have started you'll see me listed as a family lawyer, and it's true, but I've started putting divorce and custody and CPS cases to try to put the subcategories in there. Family law is anything that has to do with families. It can deal with guardianships. It can deal with custody and divorce. It can deal with CPS cases. Pretty much anything that involves the family unit, either the parents or the children, that's going to fall under family law.
Yeah, and there's so many different areas when it comes to family law. When you talk about CPS, the child support system, so many different things. The guardianship and conservatorship is starting to become a very popular topic because of what happened with Britney Spears. My wife was sitting back watching that one. I still don't completely understand that one all the way, but there's just so many different facets, and to be educated on every single one of them for these parents that are going through it, it's like speaking another language at times.
Right. That's absolutely true.
Yep. We got a comment from Summer Johnson. I do believe she had a different last name. I think she just got married over the weekend. Congratulations.
Congrats.
Yeah. Hey, guys, question. Is there any law citing how long a temporary order is good for?
Depends on the state you're in, Summer, but I think pretty much every state is the same. And I don't know, you can find case law on it if you look it up. I can't give you a site because there would probably be tons of different cases in each state. The rule of thumb is that a temporary order ends when the final order is entered. So a temporary order is usually entered very early in the case to kind of put ground rules and boundaries on the parties as to how they're going to operate until they get to the final hearing, because that could be months or even a year or longer away. So the parties are able to operate under that temporary order. Okay, here's what we're doing until we get to the final hearing. Usually the final order is entered after the final hearing, and normally that trumps the temporary order, and the temporary order is null and void at that point. But you'll want to talk with your attorney about that for sure. But that's normally what happens. They're usually good for the case, and then a final order is entered, and then that's it.
Yeah. Got a question we talked about, quite a few times here on the show from Maddox Lee on YouTube. He said, what do you do if a mom is harassing you with welfare checks during your visitation? To me, it seems detrimental to the child, as being singled out by a police officer seems scary. It's one thing, common in parental alienation to get those telephone calls every 5-10 minutes. Baby, are you okay? And if everything is okay, it gives them the idea that something is wrong. But going to the point of getting a welfare check with a police officer,
especially if you have a case going on or you think you're going to be going back to court, you need to keep track of that on a calendar. Get the officer's name and badge number that comes out. So if you need him or her as a witness at the hearing later to say, look, we came out and checked, there was no problem at all, the house looked fine. If this is happening, if she's doing this over and over, you're going to want to get a good track record of it. So your attorney, when you go to court, can say, okay, judge, here was incident 1, here's incident, and then have that officer testify, incident 2, incident 3, walk them through that. So mentally the judge gets a picture of, okay, this mom is really harassing this dad. And I've got police officers that are totally neutral and don't have any skin in this game coming in and saying, look, this dad's doing nothing wrong and his house was fine. That starts to make an impression on the judge that, look, mom is a problem.
Yeah. We got a question from William Jose. He said, how can you do child custody between states? Plus I'm disabled.
I think he may be talking about me representing people. Is that what he's?
How can you do child custody between states? Plus I'm disabled.
Or maybe he's talking about, maybe he can clarify that. He may be talking about, can joint custody operate between states? Maybe he can clarify that.
Yeah, William, clarify that for us, man, and I promise I will get back to it. Matt Powell said, why is the best interest of the child never taken into consideration in most cases?
Well, Matt, it's supposed to be. That's the poll star that judges and courts are supposed to use as best interest of the child. Now, I've had cases through the years where I felt like we knocked it out of the park. We presented all the evidence we needed to, and really made it clear what should happen. And then just the case didn't go our way. The judge saw it differently. And and you can look at that and say, I just don't think the best interest of the child was really taken into account there. But that's the poll star, and that's what the judges are supposed to be doing. So I have to disagree with you a little bit that it's never taken into consideration. I think most judges that I'm in front of do a really good job of applying that standard, but it's not perfect. And there's always times, every once in a great while, where a case goes a certain direction, and I'm just really disagree about it. And but that's what they're supposed to be looking at, is best interest.
It is. I think in each area is different too. For the most part, you're there in Arkansas where they got the shared parenting bill going. So that state has recognized the need for the 50-50. You got some of these states like California and New York. Oh man, it is a little bit all over the place, but
It is.
it really is. Maddox Lee again on YouTube said, if one parent stays in contempt for the first 6 months of the order, what are the chances of getting a change of custody for the other parent?
Maddox, that's a real good question. And if you watch us very much on Mondays, you've probably heard me say a lot that you need a track record. You need to show this judge that there's a consistent pattern of behavior on one side or the other, that the judge needs to make a change or needs to do something different with this child to get them in a better environment. What is in their best interest, just what we were just talking about. One of the things that a judge will look at is contempt. And if one parent is continually violating the judge's orders, the judges, they get tired of that. They notice it. They don't like it. They enter orders for a reason. They want them followed, and they want the parents to go follow them, and they hope that they don't see you back in their court again, that you either get along or you can follow that order and do what you're supposed to do. If one party is consistently violating it, your attorney needs to show that to the judge and show that pattern that, look, judge, no matter what you're doing or implementing, this parent just won't follow it. And we need to either change custody or put stronger parameters on this parent because, I'm trying to follow this order. I'm trying to do what you're telling me to do. He or she's not. And it's creating an unlevel playing field here. So I need some help and some relief to help with the situation.
I'm not quite sure I understand this all the way. Maybe you can, Kevin. Stephen Creasy said, would it look good for me when I go to court? My ex is only letting me see my daughter when she wants to let me see her. I wonder if that means when he goes to court, is it going to look good because he's not getting able to see his kid, but he can't help it?
Stephen, I think if you're saying that you're trying to get more time or get your visitation enforced, and you're going to be able to show that your ex is keeping the child from you, wrongfully keeping the child from you, yeah, that will definitely help you. That goes to what we were just talking about on the previous question. Judges want their orders enforced. And if one parent, for no good reason, is keeping the child away from the other parent, the judges are not going to be happy about that.
Yeah. Jared Hill here on Facebook said, my wife and I are currently separated, 6 weeks now, living apart. Her custody agreements with my stepkid's father are a mess because she moved without permission, basically in contempt. We are working on the marriage, no abuse ever. And my question is, with it being separation, is she going to lose custody for the contempt? And or is she better off moving back home immediately and treating it as if is a short separation? Thank you, sir.
Okay, let me we're working on marriage, no abuse ever. And my question is, being separation. Is he saying for the contempt with the other children? Because she's in contempt of that order?
My wife and I are currently separated. My stepkid's father are a mess.
Sounds like he's saying with the contempt from the other.
That's what it sounds like, yes.
There are several factors that the judge looks at, and one of the factors is, are you following orders? Are you doing what's in the best interest of the children by making sure the other parent sees the child, or are you not? And I think you can use that as evidence if she's in violation of the other order. I think that's what you're asking. You could definitely use that as evidence in the case that you've got. He may want to clarify that a little bit.
Yeah, man, if you get it down there for me, if we answer that wrong or we took it the wrong way, just kind of clarify it for me and I'll get back to it. Merge Music and Film on YouTube said, hi, guys, just tuned in. Big thanks from England. We've been here.
All right. I'm a huge Lasso fan.
I need a recipe for Yorkshire pudding. You ever had that, Kevin?
No, a long time ago, but yeah.
Ah, man, good stuff. Uh, Chuck Smith said, had an order overturned in Virginia at appellate level and local level court had to acknowledge it. Why are judges limitless without consequence? Ethics violation is useless and judges' abuse of authority is limitless. We have to take the loss and win at the circuit court level to get full custody because of how stubborn the judge is. Judicial bias and prejudice is real. Why aren't these judges held accountable? It's total scams. Kevin, can you acknowledge it's a travesty to dads? I think we talk about that all the time. The numbers are just completely lopsided. At the same time, we know that the other side can experience that as well.
Yeah, it's true. And, but I think there's movement in place across the country to try to get a more level playing field. I really do. And I know what he's talking about. It's frustrating. I deal, and other lawyers, we deal with the law every day. So we're used to seeing things. We know how the wheels of justice, so to speak, how they work on a daily basis. We know how appeals work. We know how trial judges work. And so when a client gets very passionate about their case, we go in, we put on a good case and lose. It's very hard for them to understand. It makes no sense. And so then you have an appeal, and the Court of Appeals says, whoa, wait a minute, Judge, months down the road. Whoa, wait a minute, Judge, you made a mistake, and we're having to change what you did, and we're going to send it back to you to fix it. Now the client is doubly passionate and upset. It's like, why didn't this trial judge at the very beginning get this right? And so it's very hard to understand and grasp that, and it's very frustrating for people. And I totally get it and understand it. And all I can say is, again, the judges I'm in front of on a daily, weekly, monthly basis, I think that we've got a great set of judges in Western Arkansas that really try to get it right and spend the time to look at the evidence. And there's always a case where you're like, wait a minute, I think that he or she totally missed the boat. I think this judge missed it. But by and large, I think they're working to try to get it right.
Yeah. Maddox Lee on YouTube said, Part 1, why do attorneys recommend that you wait 6 months to try to change custody if there's an issue and the issues are just continuing and piling up? I understand a judge not wanting to see the same case over and over, and it gives you time to build your case. But if the issues aren't going away, then the child is being put through the ringer for 6 months or better.
Well, Maddox has some very good questions. The reason that I will tell clients, wait, gather some evidence, or let's see how this goes and then get back with me. Judges do this for a long time, number one. And most of the judges you're going to come up against, unless there's been an election recently, will have seen hundreds of domestic cases. And so they've seen a lot. And whether they would want to admit it or not, as they've seen a lot more and more through the years and the years go by, it takes a little more to move the needle with them and really grab their attention. That's part of the reason. The other reason is you have this substantial change in circumstances burden, which is a very high burden that you've got to prove when you go back to court to get custody changed. And so 1, 2, 3, 4 things of mom or dad not showing up with the children exactly on time or whatever, those are annoyances. And yes, they're technically violating the order, but a judge is probably going to look at that and say that's not enough to change custody. So many times I will tell clients, look, I just don't think your case is quite there yet. You need more evidence. And because here's the deal too, I'm not in the business of trying to make unhappy clients, and I've said to clients before, I think if we go to court right now or you hire me right now, you're going to pay me a lot of money and we're not going to get you anything. And it's just not going to work. And, that's another reason you need to get an experienced attorney, one that's done this a lot and can see kind of a little bit into the future of what's going to happen with your case because of experience. And when clients hire me, I want us to have a good shot. I want to be able to help them get what they're wanting. And, sometimes you just have to have very hard conversations at the beginning and say, it's just not quite there yet. I think in my experience, in my opinion, we need to wait a little bit. Another issue is people will come back 3 months after they've been in court and say, I want to change custody now. Well, The problem you've got there is you were just in court, and the judge is going to see that in the file and think, well, you were just here 3 months ago. What could have gone catastrophically wrong in these last 3 months that now I've got to change what I did, just 90 days ago. So that's another reason that we tell people you need to wait for a while before you go back to court.
Merge Music and Film said, Dad Talk Today. Question to Kevin. Is there a profitable business model for attorneys to practice collaboratively? I'm getting tongue-tied tonight. Rather than to encourage nasty litigation. Therein lies the problem sometimes, in my opinion.
Okay, let's talk about that a little bit. That's a really good question. And I have no problem with collaborative law, and I'll explain what that is. In Arkansas, I have never been approached about it. Collaborative law is a theory that's been around for several years, and I really think in bigger cities it's a little more popular. Well, I know it is, but in Arkansas, I've just never been approached about it. Collaborative law is the idea that let's just use dad and mom as an example. Dad goes and hires an attorney, mom hires an attorney, and they enter into what's called a collaborative law agreement. And what that means is they will then work on a settlement. They might even go to mediation. But if they don't reach a settlement, then those two attorneys have to end their representation, and the clients will go get another attorney to proceed with litigation. So the idea is that those attorneys are going to be motivated and paid to settle the case as opposed to litigate the case. And the reason is they get no benefit by dragging it out, because if it goes to litigation, then they're essentially fired, and you got to go get other attorneys. I would be totally fine with doing a collaborative law divorce and being that first attorney to try to settle. I mean, I work for the client, and if it helps them reach a settlement without endless litigation, I'm fine with that. But it's a very good question, and I heard of collaborative law about 10 years ago, and I really thought it would start to catch on like mediation has, and it just hasn't, at least not in Arkansas.
Oh, wow. Yeah, great question, man. Appreciate that. Alan Schultz said, hi, Kevin. What do you know about attorneys ghostwriting the final orders because the judge is too lazy to write them?
Well, I would not use any of those words, Alan, but it is very common for the judges to have the attorneys draft the order, and they'll, at the end of the hearing, they'll let one of the attorneys or the other know, Mr. Smith, I'm going to need you to draft the order. And then they'll start reading off what their order is. And the attorney writes down the notes and drafts the order. I'm okay with it. I think a lot of clients think there's something kind of nefarious or not on the up and up going on there when that happens. And I've had clients say, well, I want you drafting the order. I don't want the other side drafting the order. Just because one attorney drafts the order, they don't send it straight to the judge and say, this is it, judge, without sending it to the other side. So, 90% of the time, the attorneys, one will draft it and send it to the other one and say, here, I need you to approve this. I'll get it and read through it. And if there's changes that are needed, I'll change them and whatever. And we send it back, and then we get it. We're not coming up with our own order. We're trying to draft what the judge ordered and put it in those words. Then we send it to the judge for signature. That's how it's supposed to work.
Gotcha. Got a comment from Mr. Jeff Aligney. He's a former state representative out of New Hampshire. Met him while we was up in the north earlier this year. He said, we seem to have many cases where mom violated visitation orders and was found in contempt 10 plus times, but never punished. Why are the courts so lenient with the preferred litigants?
I think we get this question every week, and I don't have a good answer, Jeff. I have always felt like if I became judge that, I'm going to give somebody a chance. Anybody can make a mistake, but if someone is going to repeatedly violate an order, I feel like that I would come down on them, because I get these questions like this. I get questions like Jeff's asking from clients that come in. How is she getting away with this? How is he allowed to do this? And it depends on what stage of the case you're in. It depends on how many violations there have been and how the seriousness of the violations. It's just it's a real gray area as to whether a judge will do something about it or not. And I've said on here before, I will start numbering my contempt motions if I feel like a judge isn't paying attention. I'll say, this is the third motion for contempt, judge. This is the fourth motion for contempt. So maybe they'll see that in the title and say, wait a minute, this is a fifth motion for contempt. What's been going on? And then they'll dig into the file and see what's happened in the history. But I hear you, Jeff, and it's not just you. It becomes an issue pretty much everywhere.
Steve Sharp said, "What are the penalties judges impose for contempt of court and/or frustration of visitation? For example, one parent canceling court-ordered family therapy when parental alienation is suspected."
They are all over the map. The judges have a lot of authority as far as and a wide range of punishments for contempt. Anything from just pointing at them and saying, "Don't do this again," and start following my orders. They can slap them on the wrist. They can charge them attorney's fees. They can fine them. They can take away or they can modify a visitation or custody arrangement temporarily. And they can look all the way up to putting them in jail. And anything in between. So there's all kinds of punishments that judges have at their disposal.
All right, so I'm trying to remember the comment earlier that we asked Stephen to rephrase it. He said, is it going to look bad on him when he goes to court because he can only see his daughter when the mom allows him? So he re-clarified down here. He said, I haven't been to court yet, but my lawyer is supposed to be getting me a court date, and we will go to court for the first time. But I text her and ask to see my daughter, and it's only when she wants to let me. So is that going to look bad on him? I mean, as long as he's got those texts showing that he was trying, how is that going to play in his favor?
Oh, yeah, because it's very common that she's going to, if that follows a common course, she'll come in and say, well, he's not asking for the child. He's not even trying to get visitation. And so, yes, you'll want to keep those texts and say, no, Judge, see, on May 28th, I asked. June 7th, I asked. June 21st. If you show that list, it becomes, you start to see where I'm headed with this. I want to make it to where the judge can't ignore what's going on. And if it's a one-off or two-off, sometimes they can. But if you can show that pattern, look, Judge, this is over and over. And I know this is going to take us a little bit to get through this evidence, but it's really important that you see this pattern that this dad's having to go through. And so, yeah, keep all those texts and use them.
Yeah. Jared Hell said, yes, talking about her contempt with her kid's father. My goal is to help her with her being in contempt, having moved temporarily. Is she going to lose custody for that with us, only being separated? Is she better off moving back to home of record for order? Her kid's father has always been looking for anything to use against her and us.
Oh, okay. I think I know where Jared's headed now. She's been in contempt of this order with her ex. Now he and her are separated, and I think he's concerned the ex is going to use that separation now to go after custody or something with the children. Okay, I get it now. I don't know how far the jurisdiction is away that she moved from. If she can move back, that's probably good. But normally, moving off, and if it's been for a while and dad hasn't filed anything to correct that, her moving out of the jurisdiction, most judges they just don't get really bent out of shape about that kind of thing. Now, if she moved halfway across the country and her ex hasn't gotten any visitation because of it, that could be a problem. But if he's continued to get visitation and she moved to another location and he's kind of almost acquiesced to it and hasn't really filed anything to stop it, then that may not hurt her too bad. Just talk with, I'm not sure who her attorney is, obviously, but talk with the attorney about it and see what his or her thoughts are on it.
Yeah. Got another question from Maddox Lee on YouTube. He said, part 1, back to my question about the welfare checks. I spoke to the chief in my area who has noticed that she's just trying to harass me. She called for 2 in 5 days. I had proof of her lying about her reasoning for the last welfare check. He said that he was going to get with his officers and have them use their discretion as to whether a welfare check, there it is warranted for future calls. Did I hurt my case?
No, I think you need to get that chief as a witness and any officers and have them testify about what you just told us. If I'm the judge and I hear that and have a chief come in and say, look, Judge, we're always willing to help the public, but this woman's calling constantly for welfare checks that we found nothing wrong at this dad's house. It's really a problem. That's a great witness to have on your side. So no, you didn't hurt your case.
Chuck Smith said, "You guys do an outstanding job. Thanks so much. It has been 743 days since I have seen my kids." And we see statements like that so often. I definitely know what that's like. We when we was talking to John and I interviewed him before I got to talk to you, Kevin, one of the things that he said he was doing was journals, and we have gotten to see those since he has passed on. What are some things you would say to these parents that aren't getting to see their kids? Journals. I'm just curious. I know that's not really a legal question, but any advice for these parents?
Yeah, John, and it was heartbreaking when those came out. Really was. But yeah, John would write to his children, and he stayed in touch with his family. He had some friends around him that he reached out to. You've got to do everything you can in the legal process to get that pushed forward to try to get visitation back. But that's the main thing is just act like you're talking to your child by writing something each day. And if you're a spiritual person, make sure you really rely on that part of your life. I know John did that, and that's really all you can do.
Yeah. Jeremy Lake said, "What are your thoughts on people representing themselves pro se? It better sue juries doing so in a court of equity versus the typical family court or legal commercial tribunal route. Nobody speaks of court of equity. Why is that?"
Boy, that's a lot of different questions. The first part's talking about representing yourself. I never advise that. Some people just out of lack of funds or whatever else end up representing themselves. It's never a good idea. I had a situation with a case in the last couple of weeks where a person was representing themselves and actually did a pretty good job compared to most that I've seen through the years. But it's just they weren't hardly able to get any of their evidence in because they don't know the evidence rules. And if you go in without an attorney, the other side's going to probably have an attorney. They're going to know the evidence rules. The deck's totally stacked against you if you go in there without a lawyer. So it's not really advisable. That last part, courts of equity, they were largely gone away, Jeremy, because they've been combined. In Arkansas, we used to have courts of law and courts of equity. And courts of law were usually like damages and that kind of thing. Courts of equity were designed to do what the law is always called, do equity, to find out the middle ground, figure out what an equitable resolution to a dispute is, that kind of thing. And that's where divorces and custody and family law stuff fell into, was in courts of equity. Almost all states, I can't think of any right now that didn't, but almost all states have combined their courts of law and courts of equity now. So you just don't see courts of equity anymore.
Ryan Goodwin's got a question. He said, "What is the Bar Association doing to improve the system? Do you think there is anything that they're doing trying to make changes?"
I don't know. You've got an American Bar Association, and then every state has a bar association, and then many counties. I'm in Sebastian County in Arkansas, where Fort Smith is. We have Sebastian County Bar Association. Most of the time it's there more for the lawyers to kind of get together and either have continuing legal education or something like that. So I don't know what the Bar Association is doing. They might be doing something on the American Bar Association level. I'm just not sure about that.
Yeah, I don't really think so, man. We got something from Michael saying, he said, "I just got out of supervised parenting. They kept me in for 5 years without endangerment. The judge said since it took me 5 years to learn parenting skills, he does not want to give me 25% parenting time according to our statute. What can I do?"
Well, I don't know if that was a final hearing or not. You can always appeal the judge's decision. Appeals are very hard to win, but sometimes that's your last that's your last stop. If you just had an order entered, is to appeal it and have the Court of Appeals or Supreme Court, whatever state you're in, review it. It looks like you're supposed to get a 25% time. It looks like under this statute that you're talking about. Most statutes, though, as we've talked about on here before, have what's called a rebuttable presumption, which means if the other side can show, yes, judge, this statute is supposed to be 25%, but here's the reason that it shouldn't be, and they can show enough evidence to show that he can deviate from that statute, then a judge can do that. And that sounds like that's what he did here. If you haven't been to your final hearing yet, get with your lawyer and get a plan together and see if you can overcome that at the final hearing.
Yeah. Got a little bit of a long one. It's going to cut off, so I'm going to read it from my phone. Peter Ibby said, I go to court a week Tuesday for a case conference, Ontario, Canada, and I know the judge won't make a decision, just a recommendation. My question is, how much would you recommend for trying to have as much items in the recommendation approved for an order? I would absolutely do mediation, but have been told to also see what the judge thinks first of what we are asking for before going for mediation if the other party wants.
Well, first of all, it's Canada, so I'm really shooting in the dark there. Have not had any cases in Canada. It says, how much would you recommend for trying to have as much items in the recommendation approved for an order? I mean, if you're asking all the things that you want to be put in the recommendation, I always say ask what you want. And when I'm preparing clients for court, I tell them, I'm going to question you, I'm going to ask you what you want, and I'm going to kind of lead you down a list of things that you've asked for. But one of the final questions I'm going to have for you before I'm done is there anything else you're asking this court for? And that's your time. The judge is up there to make a decision, and the judge wants to hear both sides, and the judge wants to know what you're asking for. And if you've got some reasonable requests that you feel like need to be in a parenting order, then ask for it. Just say, Judge, I'd like to have this. I'd like to have this. I'd like to have that. Just tell him or her what it is and ask for it.
Yeah. Jonathan Kendall said, what are some good technical legal terms to use, for instance, in good faith?
Well, there's a ton of legal terms to use. I don't really know what he's asking. I like to use for when. In good faith is usually in the arena of contracts. When you and I enter into a contract, we are both supposed to act in good faith to try to make that contract work together. So not sure what other terms you're wanting to know about.
Yeah. Chuck Smith said, so if a judge got it wrong and two other judges had to fix his mistake, why do I have to go in front of the biased judge who was wrong, who continually violates my constitutional rights and forces me to pay $10,000 in circuit and court appeal?
Well, I understand what you're saying. And many times I get the question from a client, okay, if we appeal, and it goes down to Little Rock, which is where our Court of Appeals is. And the Court of Appeals says, yes, we see what you're saying, and we think this judge made a mistake or needs to change something, so we're sending it back down. They will ask me, are we going to end up with the same judge we just had? And the answer is usually yes, that's where you're going to be. And again, it doesn't make much sense. I understand that, but the lower court judge is seen to have a lot of the history of the case and already know about the case. A new judge would have to get completely up to speed on it. And that's why if you win at the Court of Appeals and it gets sent back down, which is called a remand, it'll usually go back to the judge that you were in front of. And many times clients are very upset because they feel like the judge is biased against them for whatever reason. And and then the next question comes, how do we get rid of this judge? How do we get this judge to recuse so that we can get another judge? And that's very, very hard to do. You've really got to show some kind of relationship with this judge that this judge has with the other side, or some other factor that makes this judge biased in the case and not a good judge for that case. And it's very hard to do.
Maddox Lee on YouTube said, "Do you advise a dad to ask the mom to comply with court orders when she's in contempt? Will a judge look at that and say, okay, she's been reminded several times. She's failed to comply. Time to do something?"
Yes and yes. I think you should. I usually tell the first time a client calls me and says, "Look, I know we were just in court 4 months ago, but she's violated this order 5 times now, or he has. What do?" I tell them you've talked to an attorney, and that's the next step you're going to take is get the attorney and go back to court. You don't want to have to do that. Will you please start complying with the court order? And many times that ends it. So yes, I usually advise getting with the other parent first and at least notifying them, "Hey, you're violating the order repeatedly. Please start following it. I don't want to have to go back to court, but I will if I have to."
A little bit of a long one. Read it from the cell phone. This is from Taylor Grove. He said, "Sorry for the long one, but it's important. One of my big issues with family court, outside a lack of punishment for false allegations and alienation, is that the courts don't do anything to educate the outsiders in the case when lies are involved. In my opinion, any family members, babysitters, partners, etc., that want to testify in favor of mom or dad need to be informed of the whole case. For example, as a father that goes to court opposite of false allegations, the parents and others on her side never see her false allegations that are proven false. This leaves tension in the lives of the children, family members, drives the attacked parent's mental to a very low. If my child's mother knew all her lies would then be sent to her parents, husband, etc., each month via email, for example, the allegations would have stopped very quick. Why do courts want family members to continue to hate each other over false allegations when they could educate those in the case they have brainwashed?"
I think he's mainly talking about, or a big part of this is extended family possibly coming in as witnesses, and they really don't know what's going on. You have to. That's where cross examination comes into play, and we send out what's called discovery, and that's interrogatories and requests for production of documents. Basically, it's a list of questions. We want to know what the other side has as far as evidence that they're going to bring to the court hearing. And one of the big questions we always have on there is, who are your witnesses and what are they going to say? So we get those answers back after a certain amount of time. We send those to our client and say, we need you to review these and make notes on them and let us know what you think about, the other side's answers. And one of the questions I always ask my client is, okay, I want you to look at these witnesses they listed. Tell me about these people. How often are they around the kids? How often are they around you? Do they have an axe to grind with you? You would be surprised how many times the clients will say, that Uncle Bob that she's got on that list, he hadn't been around my kids in 3 years. This Aunt Susie, she hadn't been around 2 years. So and so, they saw me one time. We were out fishing 3 months ago. They saw me for 20 minutes and that was it. When I start to hear that, all of that's going to come out in court. And as soon as the judge hears that all of these big witnesses that the other side has brought in to show how bad of a parent you are have not been around, have not seen you with your children in years, et cetera, that goes out the window for that judge. It is not good evidence, and it's not going to be very effective. They want to know, they want to hear from people that are involved in these children's lives and are really seeing what's going on. So I think that's the heart of your question is extended family and how they can really listen to, let's say, an alienator's whatever you want to say, propaganda of what's going on. That's all hearsay. They can't come in and talk about that. All they can talk about is what they know and they have personal knowledge about.
He followed up down here. He said, not as witnesses. If the case never goes to trial and the family is being lied to by mom, they are never informed of the gamesmanship, which keeps tension.
Well, I agree with that, Taylor, and that is hard. When a case is over and you've got the other parent continuing to spew falsehoods, you can sue someone for defamation. There are things you can do. You could try to reach out to the other family if they're former in-laws. That's always tricky and can even be dangerous. It's hard. I mean, you just hope that it will finally calm down after a while, but it's a tough question.
Yeah, it's so tricky because you got cases where maybe you could reach them, but I've seen in these cases of alienation, they might be acting that way because that's what they was handed down. They've been through the same thing. You might have all the evidence in the world, and they still ain't going to listen to you because that's my kid, and I'm taking up for him.
Right.
I think more in a litigation, outside of litigation, if parents would just step up, if my kid was doing something wrong, I'd want to go say, hey, that's their father. You're going to let them see their father. You're going to stop playing these games. Does that always happen? No. And you want to let people know, hey, this is what's going on. At the same time, from what I've seen, especially in these cases of alienation, they love arguing.
Oh
So they
yeah.
want you to keep it going. And they
Yeah,
can't play a game if you don't participate. So it's
that's
kind of
right.
a sticky situation, Of course, you want people to know what's going on. They're making false allegations. They're doing all this. And that's gaslighting because they want you to respond, right?
Yeah, it's all stirring it up, and then you get in the middle of it, and it's so hard to take the high road, but many times that's the best thing you can do, and just ignore it. But it's hard.
It really is. I understand where you're coming from, brother. I truly do. Stephen Creasy said, could y'all come or get the word around the courts in my county? I don't know about your specific county. There's not many states that we haven't been to this year trying to get the awareness out by it. And we're going to continue to do it. One thing I would say, man, if you got legislators or anybody that you're wanting to inform, tell them to watch I Stand with John. When
Yes.
it comes to CPS, family law, false allegations, how bad the situation can actually get, everything is in that film. And I would encourage you guys, send it to your lawmakers, send it to everybody you know, and say, if you don't know what's going on in the family courts, watch this.
Yeah.
That would be
Great advice.
Yep. Hope Wagner said, can I hire a private attorney for the children?
That's a good question. That's usually what's called an ad litem. It's two words, AD and then LITEM. So if you've seen that phrase, that's some people say ad litem or whatever. You see that and don't know what it is. That's an attorney for the child. Many times the courts will appoint an attorney ad litem for the children. Sometimes, though, I've had parents ask me if they can go ahead and get the child an attorney. And I have never seen a real problem with that. The other side will probably say, well, you're paying that attorney, so obviously they're going to be biased, so there might be an issue there. But the best thing is if you're starting a case, Hope, and you're wanting a private attorney for the children, ask for an ad litem to be appointed by the judge, and then talk with your attorney about who you think would be good for who they think would be good for an ad litem, and they'll be able to advocate for having that attorney appointed.
Stephen Creasy said, how do I know that my lawyer is willing to fight for me and not just to get my money? My lawyer is just wanting me to get visitation rights and go from there. But he said if I wanted anything else, I would have to hire a lawyer and go back to court and ask for more. But it's been a year since I saw my daughter, and now it's just when my ex will let me. But what should I ask for in my first court date, and what do you suggest? That's a good question because
it is a good question, Stephen, and I don't want to get into what you need to ask for and that kind of stuff. You really need to talk to your attorney about that. I'm not sure why. It sounds like you're maybe wanting to ask for more than just visitation rights. I've been in this situation, and I don't know if this specifically applies to your situation, but sometimes you can bite off more than you can chew with a judge if you ask for way too much. And if it's been a long time without seeing the child, and the judge is going to have some concerns about bonding there, and are you going to be able to rebuild that bond? And the best way to do that is to start with visitation. And so your attorney may be thinking, look, let's get this visitation in line for you. And then if you're wanting to go back to the court in the future, you'll probably need to get a different attorney for that. But for right now, visitation, it's probably the best we can get. I mean, I'm guessing. I don't know.
Sam G said, I have a trial scheduled and my son's mother put him in a school without discussing it with me. Then went to get a reconsideration on the order we had from the initial court date and I had to take her to. What am I looking at the reconsideration hearing? First time going to court.
Sam, I don't know if you're going pro se on your own. Hopefully, you've got an attorney involved. Reconsiderations are very rare. You're basically saying, Judge, I need you to reconsider what you did. I don't think you looked at it properly, or you made a mistake of law or something like that. I periodically will have a client ask about it, and I hate doing it and usually don't. I advise them against it because I feel like they're just going to pay me money for something that's not going to work. You're telling the same judge to reconsider what they did and change their mind. So you can understand how hard that would be to win something like that. So at your reconsideration hearing, I'm not sure exactly, Sam. Sometimes new things have come up since the hearing that the judge needs to consider. I don't know. Just talk with your attorney about it. But usually, what will be focused on is whatever's in the motion that was filed. So if it's just you going, just make sure you know the other side's motion really well, why they're asking that it be reconsidered, and be able to be ready with your arguments as to why it should stay the same.
Yeah. Taylor Grove said, Eric, have you ever tried to get on Joe Rogan? I'm trying to save money to go to a UFC fight as I'm a huge fan, but my big motivation is to get Joe Rogan at a fan event before the fights to tell him to contact Dad Talk or take a letter to the stage about Dad Talk. I'm a soldier, all in for you guys. Hey, thanks for that, man. We did.
You're trying, aren't you?
Huh?
Aren't you trying to get Joe on?
I haven't reached out yet. We are definitely working on some things on the back end, guys. And that's what I said. I got to walk careful in everything that we do right now. But we've got some plans that we're working on to really get this out to the next level. I did talk to Joe's team like a couple of years ago, and this is really before Dad Talk took off. But I'd love to. And Kevin, you could go with me. We could go on there and talk MMA and smoke. I'll smoke a cigar and sit there and talk to Rogan. If you guys would like to see it, I'd say start tagging them and letting them know that you'd like to see it.
That'd be great. That'd be great.
We got through most of the questions, guys. We got a few minutes left. If you got some questions, put it down there and I'll try to bring it to Kevin. But one thing I'd like to get you to explain to me, because like I said, we talked a little bit on this earlier and I'm not as familiar with it, is this conservatorship, the guardianship. What's going on with those, Kevin? What purpose is that supposed to serve? And it seems like there might be some ways that this can really be severely abused.
They're called different things in different states, and usually a guardianship and a conservatorship are the same thing. So California, obviously everyone's heard of the conservatorship now because of the Britney Spears situation. Conservatorships and guardianships are basically almost like we're going to take a third person that's not a parent of this child or this person, and we're going to make them a parent of this child or this person. We're basically going to give them custody. Now, why would you do that? Well, with a child that's under 18, if both parents have gotten hooked on drugs or whatever and are falling apart and DHS or CPS has not stepped in yet, you may have an aunt or an uncle or a brother or a sister or a grandparent that says, we want to take these children and we want to get them. So the proper procedure to do that is to go to court and say, Judge, we know the parents have gone off the rails here, but we can take these kids and we've been around them our whole lives and we want them. And the judge will appoint them as guardian or conservatorship. Now, when you're dealing with an adult, the Britney Spears situation is a perfect situation. You've got a person here that has millions and millions and millions of dollars. They have lots of assets. They have a lot of exposure to the public. And then they start to have either some kind of a mental illness or a mental break. They start acting very erratically. It can be dangerous. And when they have access to that kind of money, they can do a lot of things that can be dangerous for themselves and others. They can get physically hurt, financially hurt. They can cause harm to others. And so what happened years ago when this conservatorship was set up for Britney, it was for that reason. They felt like she was so off the rails that she was going to harm herself financially, physically, whatever, if someone didn't come in and take over her affairs and make sure that that was being handled properly. So then recently, the big argument was, hey, she doesn't need it anymore. Now her dad's abusing it. He's either taking money or whatever. There were all these allegations. And I think now it's come to an end. So the conservatorship's over or they're going to appoint someone else or something. But That's what those are for, when you've got somebody that's kind of off the rails and you need somebody to come in and kind of oversee them.
Yep. Got it. Brianna Harper said the other party wrote out and signed a parenting with my husband and did not I for their attorney, and now does not want to agree to that plan because they are angry. Does the judge consider that parenting plan that both parties agreed to?
It depends if they both signed it, if they both, it's a little vague there, whether the attorneys were involved or not. If the attorneys sign it and the parties sign it, and it was intended to be an agreement that went to the judge for a final signature, it's pretty hard to get out of that. Just like a mediated agreement. You mediate and everybody signs that agreement at the end of the mediation and it goes to the judge, you're pretty much not getting out of that agreement.
Yeah. Hope Wagner. Okay. And my comments are going all over the screen. It said, I think you missed my statement before my question. If I did, I apologize. They're a little bit of everywhere as people was bringing them in. She said, just needed to know what to do if the children service support the parent while they are incarcerated.
I'm not sure what's being asked there.
I am trying to find it. She's okay. I'm up against abuse of power. The parent I'm up against has the backing of the children and family service reunification. Everyone knows it's all about money. The parent murdered their other parent. The children witnessed the crime. The parent made them a party of the crime. Therefore, they are victims of the crime. I'm still fighting. So let me follow that up after that. Just needed to know what to do if the children service support the parent while they are incarcerated.
I'm trying to figure that out. Sounds like maybe she's trying to say, can I get going back to the other question about the ad litem?
Yeah.
She's wanting to make sure the children have their own attorney so they can express their thoughts, maybe. I would go back to where I was. I think you've got to somehow get the judge to appoint an ad litem. And I'm sorry, Hope. I'm just trying to, it's hard to figure out exactly what you're asking.
Yeah, I am. I'm sorry about that, Hope. We are definitely trying. I'm gonna move on. Taylor Grove said, I live in Lewiston, Idaho. I met Robert Garza mostly in a quick handshake with Eric at a place called Mystic Cafe. This is the city where John Mast was killed. I will be in the courtroom when his killer is in court. Will Eric, Robert, Kevin, or Melissa be able to make it for the hearings? I know.
I think I was there that day too, Taylor.
Yep.
And that's where we met afterwards, was at Mystic Cafe. My plan, I have already marked it on my calendar to be out there. Haven't really talked with Eric yet, what his plans are, but I definitely plan to be out there, if not part of the week, for the whole week.
You know, we got a little bit of time before that gets there in case some unfortunate event that I just can't. I plan to be there, bells and whistles, ready to see what's going on. But
and I think it's okay to say this, Eric. Eric and I talk. We're on the John Mast Foundation, and so we talk with the family a pretty fair amount. And all of the family obviously is aware of that week. March 21st, 2022 is the week for the trial, and there's discussion as to whether to really have a rally or to really promote that or keep it a little bit lower keyed. And I think as a decision is made on that, that'll probably come through Dad Talk as to what's being done. So, but I do plan to be out there to support the family.
Yeah. Paul Robertson said, if I had subpoenaed multi-reunification therapists to court and my daughter's attorney called them and told them not to show up and the judge wouldn't do anything, is that corruption? Or a 7:30 eval tossed in the trash saying it had been more than 3 days since she had seen my daughter and tossed it in the trash and so on.
If you had properly subpoenaed those witnesses to be there and another attorney told them not to show up, that's a problem for that attorney. We are not supposed to tell witnesses to not show up if they've been subpoenaed. And now, Paul, I want to make sure that if you're representing yourself, that you serve the subpoenas properly. There are several little rules you've got to go by to make sure they're served properly. And if they're not, then the witness doesn't have to show up. Or if your attorney subpoenaed them, make sure they were properly done. But if they were properly subpoenaed another attorney is not supposed to tell them not to show up. That's a pretty major violation.
He said, yes, he did.
He did what?
Yep.
Serve them properly?
I think so, yeah. That came about the time you was saying that. So.
Well, you may want to, I don't know if the hearing's already over, but you may want to ask for a new trial or something if something like that happened, because that's pretty prejudicial.
Said he served him through the court.
Okay.
Hope said, I'm grandma. Thank you. It's complicated. My daughter was the victim. I'm trying to terminate rights. Okay. Okay. So that was her daughter that was murdered.
Well, that's tough. And, good luck with all of that.
Yeah. AJ said, no question. Been a follower since day one of Dad Talk Today. Just want to hear Eric finally say my last name correctly. Last name's Brought, like I brought a big ball to the game. Keep on keeping on, gentlemen. I guess I've been calling him Brout. I don't know. You know what? I give it my best guess, and you got to give me an A for effort, guys.
I thought it was pronounced AJ.
Yeah. See, I got AJ right. Taylor, this would be the last question on here. Taylor Grove said, last question, as it's just a filler question as they are running out. Do you find it silly that being an MMA fighter can be used against someone in court? It's legal and a sport. You know what, man? I have became good friends with some of the MMA fighters. We just, I interviewed one of the very first in the UFC, Dan the Beast Severn, last week, which he wasn't talking about a family court battle. It was just about the myth of toxic masculinity. But I have seen these fighters, just because they are trained, it is completely used against them, Kevin.
I could see that. I think you just have to, if you're concerned about that, you're going to have to show in court that that's just not your personality. When you get in that ring, you've got to be a certain person. But once you're out of that ring and become dad again, you're not that person. I mean, you're dad. And I think you have to have a plan in place ahead of time to make sure that distinction is made, and so that it's not, you can minimize how much the other side can try to use that against you.
Yeah. One of my all-time favorites, and he's been on this show, I'll just say it like that, is going through one of the worst cases of parental alienation that I've seen. And we will be covering that one day, but they got to get past it. But yeah, it definitely, just like, the guys in our armed forces, they get PTSD used against them. It's crazy. But guys, we are at the end of the show. I actually got to go do another show here in about 30 minutes. It got booked while we were sitting here doing this. But Kevin, tell everybody where they can reach out to you. If there was somebody that needed you on a case, maybe they need somebody to come in there and help with their lawyer, how can they get in contact with you?
I am located in Fort Smith, Arkansas. You can reach us by calling the office, 479-434-2414. You can also find us on the internet, www.kevinhickeylaw.com. That's all one word. We have a lot of information on our website and a lot of great resources on there for all domestic relation type issues that you could need help with. One of the things that I do a lot of is I take high conflict custody cases anywhere in the country. So anywhere that you are in the United States, if you want me to assist with your case, I can do that. There's a procedure called Pro Hoc Vice that allows me to get licensed for your particular case in your state, and I work alongside your local attorney. So if you're having extreme alienation, false abuse allegations, CPS issues, that kind of thing, those are the kinds of cases that I take and will come in and help you with.
Absolutely. And guys, make sure to go check out johnmastfoundation.org. Me and Kevin are both board members over there. Lots of exciting new resources and stuff that are coming up for the community that we would like you to be mindful of. And we should be meeting and trying to get some more of that coming out sometime soon. But 2 weeks from now, Kevin, let's do it again.
Let's do it again. See you then.
All right, guys. We'll see y'all next time. Hey, everybody. Eric Carroll here. Thank you for tuning in to another exciting episode of Dad Talk Today. While we fight for you, we would ask for you to please help fight for us. Like, subscribe to our channel, and ring that bell so you get notifications every time we go live. There's also Super Chats, patreon.com/DadTalkToday, and other ways you can support our channel. Thank you for being here, and we will see you next time.